Okay, today is April 4th, 2012. This is Children and Justice, and we're going to wrap up Learning Module 5 and hopefully wrap up Learning Module 6 as well. You're responsible for that through today. And I want to begin with suggestibility. That's where we left off last week. And suggestibility is related to the area that we're considering right now, investigative interviewing. I gave you just a brief overview of a few concepts involved in investigating maltreatment of children. Not all of them. It's imperative that you look at that slideshow, that narrated PowerPoint slideshow that you can see on the big board right now called Child Maltreatment Investigations. You'll be responsible for that on your examination. And I touched upon it. But at the center of a quality child abuse investigation is a good investigative interview. It's so important that we have a whole class devoted to it called forensic interviewing. Forensic meaning interviewing with regard to legal proceedings. Interviewing, in this case, children in a way that develops the best kind of evidence, the best kind of information, I should say, for a legal proceeding. That's what forensic means, about or related to legal proceedings. So, one of the most important aspects of a good forensic interview is to understand the potential impact of suggestibility on kids' memories. Suggestibility on their recollections, and that's what this segment is about. I'm not going to get too deeply into it, but I will touch upon the headings that are in Professor Meyer's book. Understanding the nuances of suggestibility is something for your forensic interviewing class. And I know some of you are in that class right now, so this will be a bit repetitive, and if you have anything that you learned there that you want to share with us, please do. But suggestibility is about the capacity for interviewers to influence a child's recollection of a past event. That's my definition. I just made up as I'm thinking it out loud here. But that's really what it's all about. Can we, through our questioning, distort, in our case, a child's true historical memory of what happened by the kinds of questions that we ask or the kinds of behaviors that we engage in? And the answer is yes, yes, yes. So we want to learn a little bit about suggestibility and what it all means so that we can minimize how suggestive we are when talking to kids and emphasize open-ended questions, objective questions, non-suggestive questions, non-leading questions that pull for free recall. We talked about those kinds of memories, free recall and recognition memory, right? Free recall is tell me what you remember. Recognition memory is tell me what happened at the football game during halftime when everybody got mad at the ref, right? Now you might say that's suggestive. Well, it provides information. It says, tell me what happened at the football game during halftime when everybody got mad at the ref. As to one issue, it's suggestive that people got mad at the ref. But if the issue that we're considering is who hit who, whether there were weapons used, or where on the field it took place, none of that information is suggestive. It is an act of cueing you about what happened at a particular time and place, and that's okay. That's a recognition memory question. Free recall is tell me what happened yesterday. I'd even suggest that free recall is tell me what happened at the game yesterday. Tell me what happened at the football game yesterday. That wouldn't be a recognition memory question. That would pull for your free recall, your ability to remember all the things that happened. When I say to you, tell me what happened at halftime at the game when everybody got mad at the ref, now I'm giving you something to lock into, something to attach to, some information for you to recognize to cue your memory. I'm cueing your memory with a focused question. It doesn't tell you the answer, though, so it's not leading. A leading question tells you the answer. I don't know who hit who. I don't even know if anybody got hit. I don't know where it took place on the field. I don't know what caused people to be mad at the ref. I have no idea about what happened there. I just want to cue you. So that's recognition memory. And we want to ask more free recall questions and less recognition memory questions if we can. But there's nothing wrong with asking questions that tap into children's recognition memory. And the reason is because kids, especially small children, especially preschoolers, are poor at providing a narrative without cues or prompts. They're not good at free recall. It's a simple fact. And we should not hold children to a standard that they cannot comply with. Right? We want to find out whether they were maltreated. We want to protect them and their siblings, and we want them to grow up healthy and well, and we want to put bad guys in jail. So we shouldn't merely ask free recall questions when we know that kids are not good at that. They ought to be treated fairly. They ought to be treated with respect for their level of development. So we simply should not throw our hands up in the air and not investigate these cases because we can't ask free recall questions of children. We have to ask some focused questions. The key is to ask the focused questions and cued questions, questions that give some information. The key is to use them sparingly and when necessary, and not to provide the answers. And give it the right mix. And when we talk about interview protocols, and I'll give you this little insight into the Finding Words protocol, which I endorse, but all protocols recommend that, or should recommend that, if you ask a focus question, or we'll call it a leading question, a question that gives information, you should always follow up with a free recall question. Right? Tell me what happened at halftime during the game when everybody got mad at the ref. Oh, there was a big fight. Tell me all about that. Instead of, well, who hit who? Well, who hit who is a suggestive question. In fact, it is somewhat leading because it assumes that what happened? Somebody hit somebody. And nobody said anything about anybody hitting anybody. So we must be very careful when we ask questions. But even if we ask a question like that and we mess up, it's okay. Just make sure that you get in the habit of following it up with, tell me more about that. Or what happened next. Or tell me everything that happened. So interviewing kids is a delicate task. And one of our major concerns is suggestibility. And I gave you my off-the-cuff definition, and that is the potential, and I may have changed a word or two here, it might be completely different. I think it's in the ballpark. The potential for investigative interviewers, the potential for someone questioning a child to influence or distort their memory of a past event, their recollections, through questions or behavior. Right? Let's take a look at that. One of the first observations by Professor Myers in Chapter 4 about suggestibility is, there is no simple relationship between age and suggestibility. And can someone tell me what he means by that? There is no simple relationship between a child's age and their vulnerability or their potential to be suggestive or to acquiesce in what an interviewer suggests, or to be more suggestive or less suggestive. There's no simple relationship between age and a child's vulnerability to suggestion. Go ahead.
So we can't say that the younger the child, the more suggestible, because there's no correlation between the two.
Yes. However, there's no simple correlation. There are a lot of variables. We can say what you said. Generally speaking, you always put generally speaking in front of every statement you ever make in life, you'll be fine. That's the way we lawyers think. Generally speaking, this, that, or the other thing. But it's true. Generally speaking, right, the younger the child, the more suggestible they are. And preschoolers, age 5 and below, are the most suggestible of all. Having said that, Myers tells us it's not as simple as that. In the sense, you may have an 8-year-old who has some kind of cognitive limitations or some kind of social issues or language issues or cultural issues or whatever, some kind of block or barrier or atypical behavior or ability that makes them more suggestible than the average 8 or 9-year-old, right? And you may have a 5-year-old who's, pretty resilient, who's not as suggestible as the average 5-year-old. But generally speaking, the younger the kid, the more suggestible the child. Okay? As Myers, citing Goodman, tells us, suggestibility depends upon the interaction of cognitive, developmental, emotional, and situational factors, including how interested the child is in the event. Young children, particularly young preschoolers, appear to be more suggestible than older children and adults. Well, that's what I just told you. Right? Older children. By the time children reach 10 or 11, they approach adult levels of suggestibility. And we talked about that. I don't know if it was in this exam or this forensic interviewing exam, but it was one of my questions. 10 or 11. No more suggestible than adults. But adults are suggestible. We do not need to have special concerns when they're 11 or older, 10 and a half, 10, 11 or older. But we always need to be worried about suggestibility with all witnesses. Myers has a heading called Suggestibility is Multiply Determined. And what he means by that is, we can be suggestive in a lot of ways. We can be suggestive in the questions we ask. How else can we be suggestive in the questions we ask? The words might be suggestive. Didn't Daddy put his hand down your pants and inside the crack of your butt? Right? That's a highly suggestive question, right? It gives a lot of information and tells the answer. Those are the words I used. What other things, Andrea, might be suggestive? The way you ask the question. Your tone, your affect. Right? There's a book by a pop culture linguist called It's Not What You Said, It's How You Said It. And that's true. Go ahead. Did you have a... What's that? Body language and behavior, right? That may contribute as well. If you're hulking over the child, you're emphasizing things with your hands, and you're using a strong tone, and you're using powerful, information-packed words, well, there's multiple things going on, right? So that's what Professor Meyer means by suggestibility is multiply determined. The other things that have little to do with the the interviewer behavior, is how developed the child is, right? What their cognitive abilities are that we just mentioned a while ago. What kind of event it was. How well it's remembered. What kind of information we're asking about. There are a host of influences. There's no single thing that tells us how suggestible an interaction is or was. And we'll look at some of those other aspects in a moment. Well, here's one. The next heading by Professor Myers is Questioning by Authority Figures and Social Demands of Interviews. Children are sometimes more suggestible when questioned by an authority figure. Moreover, young children, particularly preschoolers, appear less able than older kids to withstand the social demands of the interview. They find it difficult to stand their ground. If a grown-up asks them questions and the question's suggestive, they will co-opt, they will agree with what the adult says rather than challenge them. They're less likely to stand their ground, the real little kids, right? Does that make sense? And that's not good. We need to be aware of that. We need to be aware that that same child answering questions of her older sister may give you very different responses than answering questions from the school principal, or from a police officer, or from some other authority figure, even their parent. A grown-up, simply by being a grown-up, is an authority figure in a small child's world, right? They're grown-ups. Don't matter who the grown-up is. There's some level of authority there and disparity in social standing and relationship. So that's relevant. Suggestibility regarding central details versus peripheral details versus mere bystander. The research tells us, or at least suggests, that people, not only children, but people, are more likely to be suggestible about things they don't care about or aren't important to them. Okay? So a walk across campus on a beautiful spring day to go to the bookstore is quite different from somebody beating you down in the parking lot in front of the Kohl's store in your neighborhood, right? An event that involves stress and an event that involves interaction between you and another person, and an event where you are deeply engaged, is more likely to be encoded better, or to put it in not so fancy terms, remembered better. You're more likely to remember that better than simply something that happened between here and the bookstore. You know, some student is playing frisbee and they missed the frisbee and it bounced off the statue out front here. You know, you may have saw that, you may have encoded it, but it's not that sticky. It's encoded, it's in your memory, you saw it happen. It's recorded, so to speak, and that's a bad word because we don't record our life as we walk through it. That's part of the problem in society. It's part of the problem among lay people. They think our brains are like video cameras or a computer hard drive. Far from it. They're very complex. They're influenced by everything around us all day and every moment of the day. But in any event, you observe, you see the frisbee, you're on your way to the bookstore, it is missed by the other frisbee player, and it bounces off the statue. That's encoded, but it's not encoded deeply, if you will. It's not a sturdy memory, and thus more likely to be distorted. Why? Because you don't care about that. That's not meaningful to you. But there's another aspect to it. You're not part of that thing, right? When somebody's beating you down in front of Kohl's in the parking lot, you're not only involved in that, you're interested in that, it's meaningful to you, but you're also a participant. So things that are important to you are remembered better, and when things are remembered better, they're less vulnerable to suggestion. So watching the frisbee float by is not that important to you. You know, watch some bully pick on your brother, right, on your way to school is important to you. In both cases, you're a bystander, right? You're a simple bystander. You're not a participant. What's more important to you, the frisbee floating and hitting the statue, or some bully picking on your little brother? Clearly, the bully was your brother. Better remembered. So bystander that is interested in what's happening, better remembered. Thus, anything that's better remembered is less likely to be distorted by suggestive questions. Right? The better you remember something, the less vulnerable that memory is to being changed or messed up or corrupted in some way. So we start out with, there's two kind of bystanders, two kinds of people just watching things. Ones who watch things and not really care about what they saw, but it's part of their memory. The other one, they're deeply involved in and they really care about what they saw, better remembered. When you're a participant in some action, in something, when you're engaged in something, that's better remembered. Right? So if you're attacked in Kohl's parking lot, right? Not only is that important to you and does that matter, right? And not only is that something that's much more serious to you than watching the frisbee toss, but you're also involved in it. And people who are participants in events remember stuff better than mere bystanders. And especially if they're a participant in an event that's important to them. I'll try to be consistent with these hypotheticals. Supposing you were walking by, I'll make you a participant in an event that's not that important. You're walking by, you got your bag, you're on your way to the bookstore, you watch that frisbee fly by, it bounces off the statue right in your direction, and you adeptly snatch it and toss it back to the next person who's in that game, you smile and you walk on by. You are involved now a little bit in this interaction, but it's still not an important thing. So the more of these things that happen or that characterize the event that cause it to be better remembered, in the end, it might be really better remembered. That's a bad way to put it, isn't it? So to draft off what Professor Meyer said a moment ago about a different issue, remembering better, or the more resilient encoding, the more enduring encoding of an event is multiply determined too. So if you're a bystander or a participant, the participants remember better than the bystanders who are disinterested. Right? No, the bystander who cares about what happens is more able to remember it than the bystander who doesn't care. The participant who's involved that cares about what's happening is more likely to remember better. And then you add stress. There's some research that says stress enhances memory. Having said all of that, all memories are susceptible to suggestion. My long-winded statements to you a moment ago are just to tell you some areas are less vulnerable to suggestion. Some recollections are, some memories are less vulnerable to suggestion. And that's important. Because if you're trying to defend that this kid's recollection is good and that they are not being misled by the interviewers, you can make the observation, well, this child was molested. She was a participant. This was important to her. This is better remembered. So she or he is more likely to remember when Daddy put his hand down her stretch pants, in her panties, and in her butt. She was engaged. It mattered to her. It was highly personal, right? She was a participant. Now, same kid, right? Was the door open or closed? Was it before or after the good humor man came? Did he have shoes or sneakers on? These are memories that aren't important. You may have encoded it. You may have seen the shoes or whether the door was open at the time, but they're not better remembered because they're not important. You're not involved in it, right? You're a bystander. And another way to put this is, people are better at remembering, and that memory is more enduring and less vulnerable to suggestion about the central details of an event. And they are more likely to be influenced. That is, they are more likely to succumb to suggestion about peripheral details. And it makes sense because peripheral details are better remembered. By peripheral, I mean outside, on the margin details, not the central thing. If you came up, Gary came up and punched me in the nose, I'll remember whether he punched me in the nose and what it felt like and the fact that maybe he used his right hand, but I won't remember he was wearing a brown hoodie. Or I might say, I think it was a red hoodie. It's not important to me what color his hoodie was. What's critical, what's central to that act is that he hit me. Okay? And he hit me square in the nose and it hurt. And I know that he came up and he charged me. All of those details, if that's what happened, if he charged me, I would remember that stuff. Those things are central and critical and they're part of the experience, and that's going to be encoded better. The color of his sweatshirt is not going to be encoded better. It may be encoded, but it floats away. It's forgotten. And those kind of memories, follow my logic here, those kind of memories, you're more likely to fill in the blanks. Well, was he wearing a dark sweatshirt? Yeah. And you're not feeling that you're up as you go along, as a witness. You're not feeling that, yeah, I'm filling the blanks. I remember it was a dark sweatshirt. The suggestion by the interviewer that it was a dark sweatshirt can distort my memory. It will fill in the blank. That memory is long gone. It was there, but it's gone. But there might be some fragments of it where I get the feeling it was dark. None of that stated to the interviewer. Yeah, no, it was dark. He was wearing a dark sweatshirt, that's right. Was it brown? Let me think. Yeah, it was brown. Maybe it was, maybe it wasn't. But if something is poorly remembered, doesn't it make sense that it's more likely to be distorted by a bad question? Right? If something isn't remembered real good, then you're more likely to fill in the blanks by what somebody suggests to you about that fact. That's why we need to understand that. Now, if any of you saw the cover of the Daily News last week, now I don't know if anybody was in my class last semester. I don't remember what I taught, forensic interviewing, I think, here. I went off on the acquittal of those police officers in Lower Manhattan who responded to a distress call where it was a 30-year-old woman who was celebrating her birthday. I think I mentioned in this class too, not in the great detail I did in that class, but I give you the gist of it. She passed out, the cops came, in my view, they raped her. One of them raped her. She was unconscious, and his defense was, well, I felt bad as a former alcoholic because she was wearing no pants at her top. I spooned her in bed and sang her Bon Jovi songs. But her memory that I put my penis in her when she was sleeping, she got that wrong. Everything's true, but she got that part wrong. Anyway, they walk. And there was so much evidence. And I think I told you, I told my colleagues in the courtroom hallways, hey man, have you been following that case in New York? These guys are going down in flames. You know how these cases are hard to win. We'll call it an acquaintance rape. They're the worst. Yeah. Did you see the evidence the prosecutor got in that case? These guys, they're a mess. He said he was singing Bon Jovi songs to her. They walk. Last week, in one of the most shameful verdicts I've ever seen in my life, a woman, a totally and wholly and completely innocent woman who was just starting a job as a preschool teacher, I believe, was up in the early morning hours, and some scumbag who was out all night and wasn't meeting a girl, and when he was done in the bars after getting slapped by 2 or 3 strippers and striking out at every strip club in town, and I'm overstating it a bit, but he was in strip clubs and he struck out. That's what happened. Whether it's everyone in town, it's a figure of speech. After that happens, they have evidence that he's now calling the escort services. They got evidence. He called 3 or 4 or 5 or who knows how many escort services trying to get a girl. Can't get a girl. Then he goes to the old little black book and he's calling every girl he ever hooked up with. They're all blowing him off. It's 3 o'clock in the morning, 4 o'clock. What's your problem? Why are you bothering me? This guy's on a mission. So what does he do? He hits the streets. He's a cop. He takes a service revolver. He puts it at the head of this poor lady who's about to start her job the next day, and he rapes her at gunpoint. Not only does he rape her at gunpoint, he's so drunk and so obnoxious about it that he's making a lot of noise. People are looking out their window. They're going, what's going on? They see the guy. Now, he's not in his police uniform, mind you. They see he's on top of the girl. One of the witnesses said, I didn't know if it was, a guy and a girl hooking up, but then I looked at her face, and that sex was completely joyless, is what she said. I think that's what she used. The Daily News seemed to have quoted her. I saw somebody having joyless sex. Joyless, Joyless. In the dirt, in the back of the apartments. Now, mind you, he was convicted, but he was acquitted of sexual penetration. He was acquitted of all the rape charges. Okay? And the defense said, listen, he attacked her. We don't dispute that. All this happened. They didn't even say my guy didn't rape her. They said the prosecution has not proved sexual penetration. And you can't convict. Look, great defense. Shouldn't have been a winner, in my view, as an experienced litigator for many years in the criminal justice system. But a very good defense. Okay? It's all he had. But all he had, in my view, was nothing. But apparently, I don't know what the hell I'm talking about, because they found, not guilty, they couldn't agree on a verdict. 3 of them thought there's not enough evidence. They couldn't conclude beyond a reasonable doubt, okay, that she was sexually penetrated. They could not conclude that beyond a reasonable doubt. That was the defense's position. You only need one. One of your questions was about unanimous. When it's not unanimous, there's a mistrial. Mistrial in that case. Mistrial in that case. You know what else they found? They found his semen on her panties. The DNA was him. Unequivocally him. So there's some ejaculate on her panties. Now that doesn't mean, does that mean his penis was in her vagina? No. But it means it was damn close, right? But more importantly, and sadly, she says he put his penis in her. Isn't that enough? As one prosecutor, and all of the prosecutors and the pundits and the pontificators who weighed in, they were on the right side of this issue, but they really don't understand it. One former prosecutor said the following, and I applaud her, and what a great analogy. She said, you know what? If this were a robbery case, and some man took the stand and said that the robber, who's sitting in a courtroom, stuck his hand in my pocket and took $200 out, no one would dispute that his hand was in his pocket. No one would be suspect of whether the hand went in the pocket or near the pocket. They would accept that he felt a hand in the pocket. Yet when a woman feels another human's body part in her body, they don't accept that? Shameful. Shameful. Why do I bring this all up in the suggestibility section? Well, the New York Daily News makes a big deal of it on a cover story day 1 after the verdict. Day 2, some jurors start breaking down, talking to the media. It's learned that one of the jurors is a lawyer who fails to disclose that he plays tennis with, or has played tennis, at least on one occasion, with Cyrus Vance, who is the district attorney for Manhattan, the Manhattan DA. Well, the team of prosecutors that's prosecuting this guy is employed by Cyrus Vance. You can't have one of the jurors who's a tennis partner with one of the litigants in the case. You can't have that. And if anyone should know, now the judge cleared it. They had an in-camera review. I'm not sure how the judge ruled, and he will not release the substance of that inquiry to the media. But I don't know to me, there's no defense. You can't go in there, well, I didn't think that was important, or I did say something about that, but not directly. I said it indirectly. I mean, come on. So you have 3 holdouts. What they all agreed on that led to their belief that her recollection couldn't be trusted about penetration was that she couldn't remember. Let me strike that. Let me take that back. She got the color of a parked car wrong that was in the vicinity of where he attacked her. So if she was wrong about that, she could have been wrong about this. Now, is that the juror's fault? I say probably no. I think even a layperson should know that there's something qualitatively different between remembering and getting it right, what the color of a parked car was, and having a human body part inside your body. But what did we just learn about memory, right? What's better remembered? The central aspects of an event. Things that involve you, things that are memorable, things that are engaging, the core details. What is not so well remembered? Peripheral details. And, you don't need a class in child advocacy or psychology or social science, I think, to figure that out. But that tells me we need to educate jurors. I need to put an expert on the stand to talk about memory. Because they don't get it. And it seems to me that is so self-evident, so intuitive, so obvious, that you ought not have to educate jurors about that. But apparently you do. It also tells me something else. There's a lot of screwballs in Manhattan. Manhattan is like California in a different way. California, they say, is full of screwballs. And I say this jokingly. I have family in California. But they say California Manhattan's it's either people who are nuts, because the rent there is insane, or people that are rich. You're people that are rich, or people that are a little crazy. They want to be an actor. They're over there paying crazy rents. Not all of them, but if you put 12 people there, you get 2 or 3 screwballs. You've got 3 screwballs in that church. Just the way it is. There's more screwballs per square foot in Manhattan than probably anywhere other than California. It's the only thing I can think of. They go out of their way to find reasons, it seems to me. You've got to struggle to come up with that analysis. You understand what I'm saying? You really have to struggle. Geez, you really got to know where you want to be. And where you want to be is not agreeing with the prosecution on the issue of penetration. To come up with that. Anyway, so peripheral details, central details, not only are they better remembered, less remembered, but obviously the things that are peripheral are more likely to be distorted by bad questions. Any observations or questions?
Why are they even asking her about what color car was there?
That's a good question. I'm not sure. And again, I caution everyone. I'm relying upon newspaper accounts, and every lawyer, including myself, who's tried a lot of cases and had a lot of press coverage over the years, they get many things wrong. A trial and testimony is long, it's detailed, it's nuanced. So what actually happened, I don't know. I'm relying on newspaper accounts. But some of these things are, whether there was semen on her panties, whether he had a gun to her head, what he did beforehand. They're not going to get that wrong. That's been reported everywhere. I have to think that somehow this was relevant to location or what time of day it happened, whether that car was parked there or not. Maybe the owner of the car went to work in the morning, and if the car was there, then he had not left for work yet. Maybe time was important. There's a lot of things that litigators are concerned about that lead to inferences. So if his car was there, we can infer that he had not gone to work. And if he leaves for work at 7 sharp every day, we can now infer that it was before 7 a.m. I'm making that up. I have no idea why the car was relevant. It could be a million things similar to what I just said. So, if his car was blue and there was a green car there, then we don't know, we need to know if it's his car. I don't know the answer. But it's not unusual that peripheral details come up. It's just that you can't put a lot of weight on them. Right? Stereotypes, an accusatory atmosphere. Those of you in forensic interviewing have already reviewed the Sam Stone study. You've talked about the Salem witch trials in your discussion boards, and we're not going to get into all that here. That's for forensic interviewing. But the bottom line is, if you stereotype someone, if you interview, in our case, a child, and before the interview or during the interview, you make disparaging comments or negative comments about the person that's the subject of the inquiry, whether it be dad or the maintenance man at the school or your coach or whoever the accused molester is, if you speak of them in negative ways, then the child is more likely to say negative things. There's research that strongly suggests that. You cannot stereotype the perpetrator because it leads to the child adopting a negative perception about that person. So that's relevant to suggestibility. They're more likely to be suggestive about negative things about the guy. And that can happen like, he shouldn't have been doing that to little girls. We want to make sure we can protect the other little girls like you and make sure he goes to jail. So now the kid gets the message he's bad, he belongs in jail, and they may be more likely to respond to suggestive questions that support the proposition that he's a bad person. So a stereotype perpetrator is bad, and an accusatory atmosphere is bad, and more likely to be suggestive. Okay, Myers talks about that at length. I'm sure you read it, and you have to review it again. If you haven't, or review it. Read it for the first time and review it again in preparation for the exam. Ambiguous events are hard. When when you don't know what's going on, when you don't understand what's happening, you're more likely to be suggestive. Or you're more likely to be vulnerable to suggestion, okay? And a lot of parenting is ambiguous, right? Bathing a child, wrestling with a child, putting medicine on a child, hugging a child, kissing a child, tickling, back rubbing a child, horseplaying with a child, right? All of these things may involve direct or indirect contact with the private parts of children. And what makes them criminal are the motives of the person doing it, the adult's motives, right? So the events are ambiguous. They're capable of, ambiguous means capable of more than one interpretation. So if the stepdad is rubbing the vagina of the 4-year-old girl in the tub, he could be washing her, or he could be sexually gratifying himself. It's ambiguous. Capable of at least 2 interpretations or more. In that kind of situation, children are more suggestible. Right? So where events are ambiguous, kids and people are more suggestible. So you need to think of the kinds of questions that we can ask on a continuum. Okay? And that continuum includes, you start out with open-ended questions, and this is at the top of page 124 in Meyer's book. On page 124, open-ended, focused, specific, and then leading. Now, different child advocates have different ways of saying this, but there are at least 4 different kinds of questions that have different degrees of suggestive potential. Your open-ended questioning is the least likely to be suggestive. Your leading questions are the most likely to be suggestive. So you could say, tell me what happened, right? Tell me what happened at the football game. I would say an open-ended question is, tell me what happened at the football game yesterday. That's open-ended. Right? You got to at least tell them what the hell you're talking about. Tell me what happened since birth. Tell me what happened at the football game. Open-ended, right? That's an open-ended question. Focused. Tell me what happened at halftime during a football game. Focused. Specific. Tell me what happened at halftime during a football game when everybody got mad at the ref. Or to make it a little less suggestive, when there was a problem with the ref. Okay? Tell me what happened at halftime during a football game when something happened with the ref. Okay? So that's very specific. And a leading question is, tell me what the ref did after he hit the parent over the head with his whistle. Okay, so that's a leading question. It tells the answer, at least some of the answers, that somebody hit the parent with a whistle is packed with information. Or, to make it even more clear that it's a misleading question, the ref hit the parent on the head with his whistle. Did he? Flip it around. Didn't the ref hit the parent on the head with his whistle? That's a leading question, right? So that's the continuum. Tell me what happened at the game. Tell me what happened at the game at halftime. Tell me what happened at the game at halftime when some problem happened, something happened with the ref, and the parent hit the ref over the head with the whistle, didn't he? Okay, so you get a sense of, and we talk more about that in forensic interviewing, the continuum of suggestibility and question types. Those are question types. Any questions about the questions? Let me say this. We talked about free recall questions, and we talked about cued recall, where we give them some information. Tell me what happened at halftime when the ref got something happened with the ref. Now, that's not a leading question. It doesn't give the answer, but it cues you. It focuses the witness or the child about what you want to know. Kids are more likely to give reliable information. That is, the information is more likely to be historically true. If you had a video of what happened, the child is more likely to get it right. The information they give is more reliable when they are answering free recall questions. Free recall questions result in a higher degree of accuracy. Tell me what happened at the game yesterday. When you get that narrative, it's more likely to be accurate than when you ask a specific question or a focused question or a question that relies on recognition memory. That doesn't mean that that's not accurate. It's just less accurate. It's just to give you made-up percentages. Let's say that free recall results in 94% of the time the child's responses to free recall questions are accurate and reliable and consistent with what really happened. But when you ask a recognition memory question, when you give them some information to cue their memory, they're reliable 84% of the time. So that's pretty damn reliable, just not as reliable. Or let me make it closer so it doesn't seem that dramatic. 98% of the time the memory's pretty good, and when you ask a recognition memory question, 91% of the time it's accurate. So there doesn't mean that when kids are asked questions that have information, they get it wrong. No, they get it right much of the time. It's just not as good as free recall. And the demonstrable fact is that kids aren't very good at free recall. I started out by saying that this afternoon. And when they do give information using free recall, you don't get a lot of it. So we have to ask focused questions. We have to. And that doesn't necessarily mean that the information is bad or corrupt or wrong. There are two schools of thought about whether the interviewer should know about the case. And we talk about this in forensic interviewing. The interview that relies upon a person who has knowledge of the case is known as an informed interview. Some child advocates believe that we should do a blind interview. And the reason why a blind interview is desirable, they would argue, is the interviewer is less likely to ask leading or suggestive questions. It is knowledge of the case that fuels suggestive questions. The more you know about the case, the more likely you are to give some of that information to the child. The other kind of interview is an informed interview. That means the interviewer knows something about the case. And I believe, and I advocate, that the interviewer ought to know as much about the kid in the case as possible. Because there are so many factors that go into that child telling you what happened that you may need to address during that interview that you will not be prepared to address unless you know about the kid in the case. What if the mother threatened the kid? Or the father threatened the kid? What if the kid, when she first told, said, "Please don't tell my mother, I'm going to get whooped"? What if the kid said, "I don't want Daddy to go to jail"? You might want to know that. Because when you ask the child what happened and they go, "Nothing," what are you going to do in a blind interview? Well, when you take forensic interviewing, you'll see that we recommend a number of different approaches to let that child feel safe and let that child know it's okay to tell us what happened. And to deal with whatever emotional or psychological or factual or developmental or cultural blocks that they may have. And you won't know them unless you know the kid in the case. You won't. So that's one of the issues here that we get into in depth in forensic interviewing. Professor Myers talks about it. Okay? And he goes through rapport building and preparing the child for questioning. Every interview protocol has some of that in there. He recommends you be supportive and professional. He recommends that your initial questions be non-leading and open-ended. That you test alternative hypotheses. I just rattled off a list of ambiguous molests. Right? Horseplay, bath time, medicine application. Hugs, tickles. In all of these contexts, there is the potential for misunderstanding the motives of the accused or the adult. So you need to test the alternative hypotheses. And that means simply, maybe he was bathing her. Maybe he was tickling her. Maybe he was horseplay. And the way to do that is through an examination of context. In the Finding Words protocol, when we teach this kind of stuff, one of the role plays that we do involves a guy who's at a camp. He's a camp counselor. Okay? And the camp counselor has one of the boys, he escorts him to the men's room with a couple of boys. He has all the boys, they all go to the men's room after some activity. And he showed us how to shake our wieners. And I saw his wiener. So the facts that come in with the referral are the camp counselor's got the boys in the bathroom and he's showing them how to shake their wieners. And the kids saw his wiener. Now when that comes in, we don't know what's going on here. Maybe he's molesting them. Maybe he's teaching them how to masturbate. Maybe it's some kind of sexual event that's happening. Or maybe he's simply showing them how to go to the bathroom. Male 19 or 20-year-old camp counselor is telling them to shake their penis after they urinate. And, maybe they peeked around or you can see his penis when he's peeing. That's the alternative hypothesis. You can't simply conclude that this guy's a creepy-looking guy, he wears funky glasses, and he looked like a molester, and I'm going to ask all questions, and I'm going to conclude he's a molester. An alternative hypothesis is that maybe this was innocent. Maybe there's some other explanation other than sexual abuse. And you need to do that in all cases. All cases, if you're going to be a good interviewer. And that's what Myers talks about. And we get into that in more detail in forensic interviewing. Be wary of yes or no questions and multiple choice questions. They are good, they're helpful, but they should be used as a last resort. Multiple interviews can be problematic. First of all, from the kid's perspective, it's not ideal. They think that they're not believed. They have to relive the experience by answering the same questions over and over. We, in child advocacy, strongly discourage multiple interviews of children. But there are situations where kids have to be spoken to once, more than once, sometimes 3 or 4 times. The key is to try to minimize those interactions. I'm bringing up multiple interviews for a different reason, not the impact on the kid. Psychologically and emotionally, that's important. But it also has the potential to be suggestive. The more you ask questions, the more likely it is you might influence a kid's memory. And multiple interviews have the potential to distort a kid's memory or to be suggestive. All right? Myers gives 6 reasons in his book about why multiple interviews are bad. They may add additional stress. They may begin to relate to their experience in a non-emotional, rote fashion. That's important. As a prosecutor, that's a problem. The more the kid tells the story, the less emotionally affected they are in telling it again. The first time they tell it, they might be shaking and crying and acting like a jury expects a kid to act. But by the time they take the stand 3 years later, it's rote. It's like no biggie, not a big deal. That's a problem. Their credibility might be diminished because of the multiple interviews. They may not want to talk about it anymore. They may be inconsistent across interviews because one interviewer asked the question one way and one interviewer asks the question another way. Another behavioral thing might happen where the kid becomes more confident. The more they say it, the more confident they become in their memory, and that gives the jury a false impression about their level of confidence. You know, on the one hand, it might affect them. They might be less emotional, but they might have said it so many times, they're pretty persuasive. They're really confident. That's the way it happened. When they were a little shaky in the beginning, but they told the story so much that they don't remember what happened, they remember what they said happened. You understand the difference? All right. The sixth reason he highlights is, and the most important one on suggestibility, and I said it already, the more likely you're going to have suggestive questions. Inconsistency is part of human recollection among adults and especially among kids. And there may be developmental reasons why kids are inconsistent. And it's not because they're being untruthful. And unfortunately, we evaluate witnesses' believability in part by whether they are consistent when recounting the same event. If they tell the story once to their teacher and then to the police and then to DIFUS, if there are inconsistencies, they got that wrong. Or that's different from what they said before. They must not be being truthful. Now, among people, inconsistency is natural, but especially among children. And one of the examples that we use is an inconsistency that arises from language, and you know that I'm from forensic interviewing. Some of you know that I'm really into language. And you, in forensic interviewing, probably saw the video already. His name's not Clinton. I forget what his name is, but imagine the frontline DIFUS worker responds to the school, and the boy says, okay, he put his hand in my clothes on my penis. Okay? But the referral says, the information says that he had pants on, he had underwear on. All right. When he's questioned later by the interviewer, a second time on a different day, the interviewer says, when he was touching you, did you have underwear on? And he goes, I didn't have underwear on. Now you go look at the referral, and it indicates he had underwear on. Right? And that the molester put his hand inside the band of that underwear and fondled his penis. Now, maybe the interviewer just goes by and says, hey, it's inconsistency, I gotta live with it. But in the video clip that is presented in forensic interviewing, we learn that the boy is very specific, and this is about children being literal and specific, especially smaller children, in their worldview. You know. And he later says during his interview, I don't have no underwear on. I have boxers on. And to him, boxers are one thing and underwear is another. To some kids, pajamas are not clothes. They're pajamas. Did you have clothes on when he came to the room? I didn't have no clothes on. You were naked? No. Did you have clothes on? No. What were you wearing? Here's a good question. My jammies. Okay. You understand? So my point is, there are lots of ways that developing children can be inconsistent, right? Language and their literal worldview can present inconsistency. The way the interviewer asks the question in multiple interviews can present inconsistency. The interviewer might ask, maybe the issue is, well, was your brother in the room when he touched you? No, he wasn't in the room. The next interviewer says, was your brother there when he touched you? Yeah. Now, kids can be very literal. We've got to be careful with the kind of questions we ask. Look at the first question I asked. Was your brother in the room when Dad touched you? No. Second interviewer, 3 days later by some other interviewer. Was your brother there when your dad touched you? Yes. We need to try to reconcile that inconsistency, can't we? Is that necessarily inconsistent? What's the first question? What's the specific query in the first question? In the room. Is there a situation or a state of affairs where he's there, but not in the room? Couldn't he be in the kitchen? Couldn't an accurate response be, no, he wasn't there, or yes, he was there? Doesn't really matter, because if he's in the other room, that kind of vague pronoun question with the word there is problematic. So inconsistency can rear its head because of the kinds of questions that we ask. And it's not inconsistent. It appears inconsistent. People may declare it inconsistent. They may embrace it as inconsistent, but until you look at it closely, it ain't even inconsistent. And that, my friends, is because of the developmental issues surrounding kids. Grown-ups would say, well, he wasn't there in the room, but he was over in the kitchen somewhere. I heard noise. Or in the playroom. I don't know exactly where it was, but he was in the house. Most grown-ups would say, they'd clarify. They'd get the gist of the adult question. But little kids are very literal, right? Very specific. They listen to the question and they give you the answer. And it may appear to be inconsistent. So don't worry too much about inconsistency. We need to be aware of it. We need to address it. We need to try to reconcile it, make it make sense. But it is not a fatal blow to a child interview. And the next teaching point is, multiple interviews are undesirable, but multiple interviews by different interviewers are worse. And you can imagine taking the same pair of questions I just gave you in a hypothetical being offered by the same interviewer. Danielle, was your brother in the room when Poppy touched you? No. Later on in the interview, that issue somehow is relevant again. Same interviewer, same child, same time and place. Well, was your brother there when Daddy touched you? Yes. Well, before you told me he wasn't in the room. No, he wasn't in my room. He might have been in the kitchen. If the same interviewer is interviewing that child, there's less likely to be problems or conflict, because she or he knows they have asked that question about whether he was there in a context of this interview where she already asked about the bedroom. The subsequent interviewer may not even know that the first interviewer asked that kind of question. So it's always better to have the same interviewer. So the ideal way to interview kids, and the best way to get the most information from kids, in forensic world, it's one interview and done most of the time. Very rare to do multiple interviews. You get enough information, enough good information that way. But the best way to get a true and complete as possible account of a child's past victimization is through multiple interviews with a single interviewer who's highly trained. Same interviewer on multiple occasions. Gary.
Now, asking that type of a question, was your brother in the room or was he there? Isn't that kind of a lead as you're providing that information already in the question?
Does it provide the answer?
What kind of implies that, gives them that idea that maybe somebody was there?
Right, but is the answer, do we know the answer? Does it tell the child the answer? whether he was in the room or not. No, right? No, doesn't tell me. I don't know. It doesn't say your brother was in the bedroom, wasn't he? And so it's not a leading question, and I need to split hairs here, but it's a highly direct and focused question. But again, we need to look at questions in context, right? What if the questions before that were, tell me about Daddy touching you. Well, he touched me in my room. Who was home? Well, who do you live with? I live with my brother, Sal. I live with my sister, Gabriella. Who was home that day? My brother, Sal. When did Dad start touching you? In the morning when I got up. Was Sal home? Yeah. Was Sal in the room? No. You see, putting it in context is not so offensive. But if the first question you ask is, did your father touch your butt with your brother Sal in the room? Then that would be an offensively leading question. But one way to ask that question to be not so suggestive, not leading. Leading gives the answer. Suggestive suggests options or information. Tell me how to ask that question better.
Who else was in the room?
Well, that suggests that someone was in the room. Change it a little bit more.
Was there anyone in the room?
Yeah. We didn't ask about a brother. Was someone in the room? You said you were in the room. Who else was in the room? Was someone, or was, who else implies there was someone else? You were in the room. Now Dad touched you. Was Dad in the room? Yeah. Was someone else in the room? No. I mean, you need to ask about eyewitnesses, right? So you just can't go out. But you're right. It gives some information. But I suggest to you that if we look at it in context, it might not be so offensive. But the better way to ask it, Gary, you're right, is to say, was someone else in the room? Not to give the brother. We don't need to give the brother's name. If we do, I'm saying, it's not that bad. Not that bad. But we can always ask it better. And by making the question generic, we're making it better, rather than being specific. Good observation. Any other observations? Very good. Okay. That's chapter 4. Let me tell you a little bit about Margaret Kelly Michaels. Again, that is for another course. Margaret Kelly Michaels was a young woman who lived in Pittsburgh, Pennsylvania. She moved to New Jersey, not far from where we are seated and standing in Essex County, to Maplewood. And in Maplewood, she got a job as a teaching assistant. And while she was a teaching assistant, one of her students, a little boy, went to the pediatrician with his mom. And when the doctor was evaluating the little boy, he took his temperature rectally. And I'm not so sure that pediatricians do that much anymore. I think this ear thing is a lot more accurate and less intrusive. But back then, this was the early 1980s, they still, for children, used a rectal thermometer. And they took the temperature. And he made a statement similar to, that's what Miss Kelly does. And without getting into all of it, from that, there were other questions. We knew that Miss Kelly was his preschool teacher. Why in God's name would he be doing anything like that to his butt? So there were questions asked by the pediatrician and by the mother. Other questions were asked of other kids. And eventually there's a 139-count indictment where Margaret Kelly Michaels is accused of molesting dozens of children in the most bizarre and unusual ways during school. Playing the piano naked, putting peanut butter on the kids' genitals, having them lick peanut butter off each other's bodies, and on and on and on. And penetrating them with objects, spoons, forks, and the like. There were a astonishing number of investigative errors made in that case. Now again, that was at a different time. We really didn't know what we didn't know back then. Nevertheless, that case and similar cases stand for the proposition that investigative interviews and child abuse investigations have to be done delicately, they have to be done with respect for children's development, and they have to be done in a way that allows the child to express what happened rather than the interviewer expressing what happened and the child adopting what they say. One of the most important issues before the court was whether those children's memories were unfairly influenced by the investigator's questions. What we've been talking about all morning, right? Suggestibility. All afternoon. And the appellate division threw out Michael's conviction. It was overturned. She was given a new trial. Prosecutor's office appealed to the Supreme Court of New Jersey. The Supreme Court affirmed the appellate division and threw out her convictions and said she needs a new trial because so many bad things happened. We're not going to get into it, but investigators offered kids toy badges and said, Miss Kelly's a bad lady. Don't you want to see her go to jail? Don't you want to do what all your friends did and tell us what the bad lady did? Just in a modern, looking at it with modern sensibilities, just staggeringly bad questions. Back then, whatever. Supreme Court said, this is not good. We're reversing her convictions, we're releasing her on bail, and you can have a new trial. And prosecutors, we're not saying she's innocent, we're saying she gets a new trial. But before that new trial, there has to be a special hearing called a taint. T-A-I-N-T, taint. Taint meaning to soil, to dirty, to corrupt, to stain. A taint hearing. And the taint that they're worried about is the taint that's caused by bad questions. That somehow that memory, the kid's memories for what may have happened, was tainted, or distorted, or soiled, or dirtied, or stained, if you will. It's a metaphor by bad questions. Is their memory pristine, or clean, or somehow is it tainted? So before the prosecutor's office can retry Margaret Kelly Michaels, they need to have a hearing on the suggestibility of the investigation. It's really a suggestibility hearing. It assesses, to use the legal characterization, a Michaels taint hearing evaluates the impact of the investigation and specifically the investigative interviews on the child's memory of the events. One more time. The taint hearing evaluates the impact of the investigative interviews on the kid's memories. Did the interviewers mess up those memories and give them the answers or tell them what to say or put ideas in their head, right? And the court said the trial judge, the judge who decides whether all this stuff is going to be admissible before the jury, has to answer this question. Can he reasonably or she reasonably conclude that the kid's memory is from what happened to them or has the kid's memory been so distorted or so influenced by the adults who conducted the interviews that we can't tell whether they are remembering because it happened or because it was told to them. The court has to make a legal ruling about whether these kids' memories have been so distorted, so influenced, that it would be unfair for them to tell their story to the jury. So the central question in a Michaels hearing is the child remembering what happened because they remember it? It's been encoded, and they're retrieving it, they're recalling it? Or is their memory a recollection of what was suggested to them? That's the central question for that hearing. And if it's substantially likely that the children are remembering it because it was suggested to them, the kids don't get to testify. And if the kids don't get to testify, ain't no case. Right? I call it a motion to suppress the child. You know, in the law, when somebody does an illegal search, if the police don't have probable cause or a warrant and they break into somebody's locker at work and they find a murder weapon, they have a hearing in court to determine whether that gun will be allowed as evidence in the case. They call that, in the law, motion to suppress. Motion to suppress the evidence. What suppressed the gun? And it's to deter, to stop cops from not following the Constitution. Cops are less likely to violate the Constitution if they can't use the evidence they get. So you suppress the evidence. You suppress the gun, no case. Why call this a motion to suppress the child? No kid, no case, right? Why are we talking about Kelly Michaels and children in justice? Because it has to do with suggestibility, right? It's a suggestibility hearing. All right, let's take a look at some of the other parts of your assignments. The tender years exception to the hearsay rule. Okay? Among your readings. In fact, let's put it up on the big board. Now, the first thing we need to do is understand what hearsay is. And I'm going to teach you hearsay in 90 seconds, although I had to spend the better part of a semester understanding what it meant. But for our purposes, a hearsay statement is when somebody says something and you're not in a courtroom. Let's start with that. It's a statement that's made outside of a courtroom. Am I making a statement outside of a courtroom right now? Yes. Am I in a courtroom? No. It's a statement made outside of a courtroom that's offered in the courtroom. That is, somebody is offering it as evidence in a courtroom. Because they want the jury to believe it happened. Because they want the jury to believe that what the words are of the statement are true. And just write that down or make a mental note of that, and I'll give you examples. It's the best way to appreciate that. But the bottom line is hearsay is a statement that's made in anywhere on the planet but a courtroom. And then some lawyer says, I want that statement said again. I want somebody to repeat what was said outside the courtroom, in the courtroom. And not just because those words are poetic or magical to me, but because I want the jury to believe that what those words say is true. Statement outside court, offered in court for the truth of the matter. That's the kind of legal definition. A statement made outside court, offered in court to prove the truth of the statement or of the matter. Officer Bill Mott is a sturdy former Patterson cop, and he works over at Eastside High School in Patterson. He's one of these police officers that is assigned to a public high school, or any high school for that matter, to keep order in the high school. One day, Danielle comes in. She's 15 years old, and she knows Officer Mott for a long time. She trusts him. And she says, listen, that new custodian, he stuck his hands down my pants and started to touch my vagina. Right? Bill Mott says, tell me more about that. Officer Mott, M-O-T-T. And she says, well, when I went back there to drop off all the erasers from the art class, he was in there. He started talking to me, and then he kind of pushed me against the wall, stuck his hand down my pants and touched my vagina. Okay. Bill Mott calls his friends over at the prosecutor's office. They launch an investigation into sexual assault with the school custodian. Before there's going to be a trial, there may be a hearing on bail. We talked about bail earlier in the semester. There may be a hearing on bail. There may even be a hearing on whether there's probable cause in this case. And it has nothing to do with guilt or innocence. It's just to decide whether there's some evidence that he did this and what the case is all about. So the prosecutor calls Officer Bill Mott as her first witness in the bail hearing, probable cause hearing. It's a pretrial hearing. Not so much about guilt or innocence, but whether there's enough evidence to suggest that he did something that would be criminal. Probable cause. We've talked about that. The first witness is Bill Mott. Bill Mott takes the stand, and he sits in the witness chair, and he's inside a courtroom. And Nancy, the prosecutor, says, Officer Mott, did you speak to a young woman at Eastside High School on January 5th, 2012? I did. Where did you speak to her? Right outside the janitor's closet where their offices are on the first floor of the building. Did she tell you about something that happened in that area on that day? Yes, she did. Tell me what she told you, Officer Mott. Me. Hearsay. Let's look at it. Tell me, Officer Mott, what Danielle told you that day on the first floor of Eastside High School. Well, Danielle told me. Beat, freeze frame, objection. Why? We're asking, right? We're asking Officer Mott to tell us some other person's statement. Where was that statement made? Outside the courtroom. It was made at Eastside High a month ago, or a week ago, or a few days ago. Okay. We're offering an out-of-court statement. Bill Mott's going to tell us what Danielle said, and where is the statement being offered? In a courtroom. And what does Nancy, the prosecutor, want the judge to conclude if Bill Mott's able to say, well, Danielle told me that the guy put his hand down her pants and touched her on her vagina under her panties. Why is she offering that? Because she likes to tell salacious stories? Does she want the judge to conclude that that's what happened? Does she want the judge to conclude that the custodian sexually touched Danielle without her permission? Is that the end game here? Yeah. Because we want to show that this guy probably committed a crime and he needs to be held at a high bail. Right? So we're offering that statement to prove its truth, that it happened. Because that's important. Whether a guy, that's the central question in the case. Did a man touch a woman's genitals without her permission? So we have an out-of-court statement offered in court for the truth of the matter. Professor Myers gives you different examples, right? Especially with kids. Mommy, Big Billy down the street put a stick up my bum. What? What happened? Big Billy down the street took a stick, he put it in my bum. It hurt, Mommy. You put Mommy on the stand. What did little Jerry say? Well, little Jerry said that Big Billy, stop, objection, hearsay. Oh, what's the problem? Well, if Mommy tells us what Jerry said about Big Billy down the street, well, let's see, would that be hearsay? Where did little Jerry make the statement to Mom? Was it in a courtroom? No, it was outside of court. Is it being offered in court? Yes. Do we want the judge or the jury to conclude that some big kid down the street put a stick in the buttocks or the anus of little Jerry? Yes. Right? So that would be hearsay. The problem is, with banning hearsay, some hearsay is important and good and necessary and helpful. But there's a reason we ban hearsay. Can someone suggest or tell me why we don't allow hearsay?
Because the person in question wouldn't be there to authenticate such things like you said.
Well, that's a good observation. The person who experienced it, who said it, isn't on the witness stand. So it is arguably less reliable because you're just repeating what someone else said. So it loses some of its reliability, right? What else? Go ahead.
You remember that game when we were little, we would play the telephone?
Yeah.
People would change. The story changes from person to person.
Correct. It might be, the information that's offered for the truth of the matter stated might be less accurate. Right? It might be less accurate, number one, because the person who said it is not on the stand. Number two, when people communicate to other people, and it goes through the filter of one human or another human or another human, the quality of the information degrades. It gets less reliable. And perhaps the most important point to the court is that information is not subject to cross-examination. The person who made the statement might have a motive, or might be a liar, or might have said something purposely wrong, or they might be biased, or they may not like custodians, or they might not like big kids with sticks, or they may be liars, or they didn't have their glasses on, or maybe it was raining out, or maybe they don't know, they confused Big Billy with Big Buddy. But that person who made the statement, their believability, their perspective, their recollection, the quality of their perceptions cannot be explored, right? Because they ain't in a courtroom. You couldn't interrogate and cross-examine Officer Mott all day. You're not going to find out about Danielle, because she ain't in court. You could cross-examine Mom all day about little Jerry and what happened with Big Billy, but you're never going to find out whether little Jerry had a motive, or an axe to grind, or was wrong, or was not paying attention, because he ain't on a stand. So it affects a fundamental aspect of our jurisprudence, of our way that we run the legal system in America, and that is the right to challenge witnesses and find out who they are and what were the circumstances around their statement. You can't do that when you got the dude on the stand who didn't experience the event. I like to call it the best witness rule. Who's the best witness? Mott or Danielle? Mom or little Jerry? Little Jerry and Danielle, right? They lived it. That's basically what Gary said. However, the most important thing to the courts, though, is people can say whatever they want in this world. Things are easily said. And people have all kinds of motives for saying stuff. And the court system requires, the Constitution requires, that we examine the circumstances around their experience. It's all about reliability. Having said that, having told you that hearsay is banned in the criminal courts in New Jersey and every other state in this country, there are many, many exceptions. Some would say so many exceptions that hearsay is a dead principle. It's not, but some might suggest that. I'll give you a couple of quick examples. There's a hearsay exception that's a few hundred years old, and it's called the dying declaration. And that simply means that if somebody makes a statement, knowing that they are about to die, let me change it, believing that they are about to die, and death is imminent, then that statement is admissible. And the rationale is that people who believe they're going to die, people who are about to meet their maker, are less likely, dramatically less likely to lie on their deathbed. They don't want to pass on to wherever we go with a lie on our lips. So the information that is offered by someone on their deathbed is more reliable than the general information that people offer or say. Other exceptions. Statements made to doctors for medical treatment. When we go to the doctor for diagnosis or treatment, we don't just go to the doctor to find out whether they want to buy tickets to the PBA dance. We go to the doctor to get treated. We say, listen, every time I raise my right arm it hurts, or I'm getting chest pains, or I have night sweats, or my big toes tingling, doc. Help me. I need treatment. Statements that we make to our physicians in furtherance of treatment, when we want to get treated, are considered more reliable than the general statements. Thus, there's an exception for statements made when patients are seeking diagnosis and treatment for an illness. Why is that considered more reliable and thus probably admissible? Go ahead.
They want to get treated correctly, so if they lie, they're not really going to be treated.
Yes, there is an enhanced motive to tell the truth. You certainly don't want to tell your doctor the wrong information. You want to get better. I mean, there's a lot of interest that a person has in telling the truth there. Go ahead.
So now, is that to say that the only person able to give that type of information is the doctor, not someone who was standing in the room while he was talking to the doctor?
Well, if your purpose is to seek treatment, and members of the doctor's staff are in the room, then that's okay. The hearsay exception would apply. The rationale is based upon your desire to get better and the fact that you're experiencing some illness or some pain. And the fact that there's a third party there shouldn't change that dynamic. And it doesn't even matter if it's a doctor. You could be screened by the nurse or a physician's assistant or some other paraprofessional. If you're in a medical context and you're there to give a history and you're desiring treatment, you're going to be okay with the medical diagnosis and treatment exception. We'll talk more about confidentiality in the same context later on. That's a little bit different when you have a third party in the room. Whether that discussion is confidential is a little bit different. So there are a number of hearsay exceptions. One of them that we have on the big board was specifically designed for children under 12. Okay? And this is called the tender years exception. The tender years exception, and it's in your readings for today. In the example I gave you about Danielle to Officer Mott at Eastside High, her statement would not be admissible most times. Her statement would not be admissible. But here, if the kid's under 12, it may be admissible. And in the second hypothetical I gave you with little Jerry, who said, Big Billy down the street put a stick in my butt, that scenario might lead to a hearsay exception. This hearsay exception. Here's the elements of it, without reading that out loud. The child must be under 12. They must have made a statement about a sex act upon them. Not on their sibling, not on the kid down the street. Okay, so the elements are a statement made by a child, okay, about a sexual act upon that child is admissible if the court finds that based upon the content and the context, it's trustworthy. So the court has to listen to the story before they let the jury hear it to see whether it comes out in a reliable way. Okay? A statement by a child under 12 as to sexual misconduct committed with or against that child is admissible if you tell the other lawyer about it and the court finds that it's trustworthy. Okay? So, elements, kid, under 12, sexual abuse statement about sexual abuse on that kid. Child under 12 makes statement about sexual abuse that happened to the child. So a 9-year-old who witnesses dad raping their 8-year-old sibling cannot have their statement come in. They can come in and say what they saw, but mom can't come in and say my 9-year-old told me she watched my 8-year-old get molested by my ex-husband. That would not be admissible. The witness has to be the one who experienced the sexual abuse. Similarly, if the 9-year-old comes in and tells us how dad put out cigarettes on her arm, and it's trustworthy and compelling, it ain't coming in. Why? It's not a sex act. An element is missing. Kids under 12, it's abuse. It's trustworthy. It happened to that child, on that child, but it's a physical abuse act. This only applies to sexual abuse. And it allows us, in law enforcement in New Jersey, to get in these video recordings that we do. You know, we video record the child interviews throughout New Jersey, right? You may or may not know that. That's what we do. We record on video the forensic interview. So we don't have to worry about Margaret Kelly Michaels and people saying we're highly suggestive and we ask the wrong things. We document it. We have a video. It's exactly what the kid said, because it's a video. If we bring that video and offer it in court for the jury to see, is that hearsay? It's exactly what the kid said. They're not going to get it wrong because we recorded it. Well, let's see. Where was the statement made? Outside the courtroom, in the prosecutor's office. Where are we offering it? In court. Do we want the jury to believe what's said during that interview and documented on that video is true? Yes. It's hearsay. But if the kid's under 12, the video's coming in. Provided it's trustworthy and nobody misled the child or corrupted that child's memory. Okay? That's the tender years exception, and that is very powerful and important evidence in child abuse prosecutions. It is a game changer. When the Supreme Court of New Jersey told the legislature to consider this kind of hearsay exception in the early 90s, and the legislature adopted it, it really changed the game and leveled the playing field. Because now we get the child's statement at or about the time they first told, and the jury gets to hear it and see it, rather than that child 3 years later, when they're older, maybe less appealing as a witness. By then, maybe their recollection is now mechanical and rote or practiced. We talked about all the things that happen as time goes on. We get to see the kid now at or about the time they first told. Without being cross-examined, just simply telling their story to someone who's open and neutral and objective and nice. And that is good stuff. So good that defense lawyers in this state tried not once, but twice to get this repealed. Not once, but twice. And the second time, they almost succeeded. And both times, I, among others, but largely, say a nice thing about myself, started a campaign to convince them to do otherwise. And the second time, I testified before the Senate Judiciary Committee in Trenton to tell them this was a bad idea. And to defense lawyers who suggest that this is distorted or results in unfair treatment of defendants, or it is unfair and it leads to miscarriages of justice, that's not what it's about at all. And it has survived to live another day. But one day it will be back in the defense lawyer's sights, and they'll try to get rid of it, I predict, again. And hopefully we'll be ready. You get to see it, you get to play it, the kid gets cross-examined, the kid comes in the courtroom. Yeah, you can't cross-examine the video, but the kid will be there. You can ask them 1 billion questions about what they said on the video. So anyway, it's good stuff, and it's fair, and it's important for kids and for the truth. Any questions about hearsay and the tender years exception? Okay, I'll see you all next week, and we'll finish up Module 5 and